Hi and welcome back. We're going to now study ordinances, which I think is extremely important as far as this year's mains is concerned. And a broad outline of how we are supposed to study ordinance is actually fairly simple. We must first understand from an introductory point of view certain basic essentials out of it, and we must also understand the constitutional history behind it. Once we understand this, we should also supplement it with a little bit of data and get some interpretations and clear some confusions as far as ordinance related data is concerned. We should supplement it with with a little bit of current affairs as to what are the recent ordinances that are actually in force or the recent ordinances that have been promulgated. Once we understand this, we must then understand the procedures and the powers in detail. Once we've understood this, we should then understand exactly what are the three very important Supreme Court judgments on it. And then, of course, the fundamental principle of the ordinance is separation of powers and how the ordinance essentially conflicts with parliamentary democracy, supplementing it with a conclusion as to how should ordinances largely be placed. It is a very interesting discussion. It is extremely important in the context of parliamentary democracy, in the context of bicameral legislatures, in the context of how the Rajya Sabha essentially does not have the concept of a political majority, and so on and so forth. So let's start right ahead and let's figure out exactly what it is that we must know as far as ordinances are concerned. So basically, ordinance is a twinning power. The powers of the president and the powers of the governor with respect to ordinances are fairly similar. President gets the powers under Article 123 and the governor gets the powers under Articles 213. So it's basically a law which is temporary in nature, which is promulgated by the president on the recommendation of the Union Cabinet when either of the houses of the parliament are not in session. Similarly, ordinances can be issued by the governor of a state or the lieutenant governor of a union territory with a legislature or with irrespective of whether the state has a council or an assembly, and so on and so forth. As I said before, they are twinning powers. Now the idea is the technique of issuing an ordinance has been devised with a view to enable or to sort of create or to fill a void of urgency. The key words are that the reason you are essentially empowering the elected executive to directly recommend to the president a law which has to come into force without the sanction of the parliament, and this is an extraordinary exercise given how obsessed we are with parliamentary democracy. The reasons for doing this must always be unforeseen and urgent, and if they are not, then of course there are larger issues that we deal with. Historically speaking, the provisions of the ordinance have always been a part of the Indian administrative setup, whether we've been under independent rule or we've been under the rule of the British. Very specifically, the Government of India Act, sections 43, 44, if I'm not wrong, but the sections are not relevant. Government of India Act 1935 essentially spoke of parallel legislative powers which vested with the Governor General of India, which is also interestingly why until the Constitution came into force, which is on the 26th of January 1950, any ordinance, whether it was post-independence or not, was actually issued by the Governor General. It is only after the 26th of January 1950, when the Constitution comes into full effect, is when the ordinances at the central level, of course, get issued by the President of India. From a constitutional debate perspective, K.T. Shah is the man of the hour, whether it was the stance that he took as far as separation of powers was concerned. Similarly, K.T. Shah actively participated and was extremely critical and cynical about the use of ordinances. In fact, he had an issue with the duration of 6 weeks which is required post the commencement of the next session of the houses, and he was extremely wary of the idea and the utility of the ordinance. Even Dr. Ambedkar wanted to always not favor ordinances as such, but ultimately lay it in the wisdom of the president and the governor to only enact ordinances which were absolutely incredibly essential. So apart from that, interestingly enough, there wasn't a lot of debate in the Constituent Assembly on ordinances. And this is in fact a matter of great surprise and an interesting anecdote, that the Constituent Assembly should have debated more on the utility and the perspectives of the ordinance than it actually did. Now, when we look at the recent ordinances, there are actually a few which are in force. A few have been negatived in the sense that they've been enacted into proper laws. Let's look at the ordinances which are currently in force and will be in force, I think, by the time you write the mains exam. So the Delhi Special Police Establishment Ordinance of 2021, which essentially seeks to extend the tenure of the CBI director 1 year at a time to a maximum of 5 years, and the Central Vigilance Commission Ordinance of 2021, which wants to do the same for the director of the Central Vigilance Commission, which is the apex anti-corruption body, and in fact the CBI works under the supervision of the Central Vigilance Commission, and the tenure should also be extended to about 5 years. Both of these ordinances are in force. Substantive ordinances. Whereas the Narcotic Drugs and Psychotropic Substances Ordinance, which might sound incredibly important given recent developments of certain very well-known people who have allegedly been involved in narcotics and psychotropic consumptions. This ordinance was essentially to rectify a drafting error in terms of the punishments that had to be applied as per the new law, which was amended a while ago. Apart from that, we've seen the tribunal reforms ordinance, which then converted into a law, and so on and so forth. We've seen a lot of these ordinances which have therefore been converted into a law. For example, earlier this year, there was also an ordinance on the Commission of Air Quality, which was essentially issued on the recommendations of the Ministry of Environment and Forests, and we passed it in the earlier session. So there are several ordinances legitimate in nature which converted into proper laws once the Parliament came back into session. There are several ordinances which don't make any sense in terms of the urgency or the nature of it being unforeseen, and there are certain ordinances which have obviously been promulgated from a very opportunistic point of view. And we'll analyze that in a fair amount of detail. But this is essentially how ordinances are currently playing out as we speak, and should be playing out while you're writing the mains exam. A better understanding of ordinances would be through the data that we look at it. But we basically understand what an ordinance is. An ordinance is basically a temporary law which is drafted by the ministers at the center or the state respectively, and instead of sending it to the central or the state legislatures, as is directly sent to the president and the governor, and the law comes to be in operation. Now, if you just think about it very logically, there are very simple questions to an ordinance. The first question is, what is so urgent about it? The second question is, can you do it more than once? The third question is, what happens once the legislatures reject an ordinance? Does it continue to remain in operation or not? Which is also where the Supreme Court steps in. And lastly, the idea of an ordinance transgresses separation of powers, because the executive through the president is actually performing a lawmaking function without sort of the sanction of the parliament per se. So there are multiple perspectives to an ordinance, and we do expect questions in the exam, and you could use ordinances as examples of separation of powers, as examples of overlapping checks and balances, and so on and so forth, and also how a lot of times the courts have gotten into the review of ordinances as well, whether it is an ordinance which was essentially to implement a court judgment. In fact, when the Supreme Court had pronounced the triple talaq judgment, the Parliament had actually the government had actually first promulgated an ordinance criminalizing triple talaq, which later got converted into a proper law criminalizing it and invalidating it. So there is a cycle to it, there is a judicial reviewability to it, and there are of course certain discussions and ramifications to it. Now let us examine the data as far as ordinances is concerned. One of the primary sort of lenses that we look at as far as ordinances are concerned is that a government may be forced to take the route of ordinances because the government might be a coalition government, or the government might not have sufficient representation in the states, thereby not having a promising number in the Rajya Sabha. What is very interesting to note is that irrespective and in spite and despite of formats of governments, India has seen an extraordinarily high amount of ordinances, which is worrisome. And it's not just the current government or the government right before this or the Congress or the BJP. Irrespective of who's been in power, the extent of the usage of ordinances has actually been a fairly high amount. The data that really hits us hard, and I think you should quote this data, is that between 1952 to 2014, governments across the board had issued a total of 637 ordinances. That approximately averages out to about 11 ordinances a year, or almost one ordinance a month, given the fact that the parliament only sits about thrice a year, and so do state legislatures in the BMW format, which is the budget, monsoon and winter format. What is also very interesting to note is that the immediate advent of independence and the enforcement of the constitution, the first 15 years or so, between 1952 to 1964, about 70 ordinances were promulgated. That's especially at a time where a political party enjoyed unquestionable status in the country. The emergency period, of course, very logically and very obviously saw the promulgation of 77 ordinances in a span of about 6 years. That's between 1971 to 1977. And several of these ordinances were also challenged in the court. Now, if I do a current data analysis, and I've picked up this data officially from the legislative department of the Ministry of Law and Justice's website, where they've given very detailed PDFs on the nature and attached ordinances. If you see, in 2021, we've already issued about 10 ordinances. In 2020, given the fact that it's a pandemic year and it could sort of be justified, we've issued about 14 ordinances. In 2019, and there was no reason to do so, the government had just come to power, we saw 16 ordinances, about 9 in 2018, 7 in 2017, 10 in 2016, 9 in 2015, 9 in 2014. Which means that there has been a high degree of ordinances. Even before that, about 11 ordinances in 2013. We've only had one good year or so in the last decade or so, where in 2012, we just promulgated the one ordinance, and I think it was an AIMS-related ordinance, if memory serves me correct. But on an average, we do see a large number of ordinances averaging out to about 10 a year. So you could actually oversimplify the data and you could write that across the last 10 years or so, we've seen on an average of about 10 ordinances on a yearly basis, whether we've had a majority government or a coalition government in place, which of course is a problem. If you do want to score a bit of brownie points and you want to sort of get into the history of it, I did some research and I found out that the first recorded ordinance in the history of this country is the Indian Paper Currency Ordinance of 1918, which is officially recorded by the government. The first ordinance of independent India, interestingly, is the Press Special Powers Second Ordinance of 1947. And up until here, as I was telling you before, it's the Governor General who decides to finally promulgate the ordinances. And the first ordinance, post the enforcement of the Constitution on 26th January 1950, while all parts of the Constitution come into force, is the Parliament Prevention of Disqualifications Ordinance of 1950, the first ordinance that comes post 26th January. And the first ordinance of independent India is the ordinance that comes post 15th August 1947. Now this is just trivia related data in case you're interested. But the real analysis of data actually lies here in the first few points, where you're able to sort of get a hang of where exactly are we with respect to ordinances. And this sort of reinforces the point that irrespective of the format of the governments in power, whether it is a majority or a coalition or any other form, ordinances have been a reality of the development as far as India has been concerned. Now that we understand this, we should then look at some basic ordinance making powers of the executive. But when we talk about the president, you could interchange it with the governor. You could also draw a diagram like this in your mains answers. So the basic idea is that the parliament is not in session. You require an immediate action, must be approved by the parliament within 6 weeks of reassembly. Ordinances can be retrospective if they're made on a civil law. Ordinances are subject to judicial review. Ordinances have nothing to do with the power to proclaim national emergency. That's a completely different thing. It seems similar. It seems bypassing legislatures, but they're essentially not the same. And ordinances are not a substitute for legislative action. The idea here is the powers to make ordinances are coextensive with their corresponding legislatures, which basically means that the power to draft an ordinance by the president is coextensive with the parliament, and the power to draft an ordinance by the governor is coextensive with that of the state legislature. The power to draft an ordinance by a lieutenant governor would be coextensive with the union territory and the legislature of the union territory. So you do not have ordinances in union territories without legislatures, because you do not have regional lawmaking power per se. So it's only the president, the governor, and the lieutenant governor of union territories with legislative assemblies who would have ordinance making powers, because they're coextensive in nature. So this is largely the ordinance making power and certain key features. You would not be asked a detailed question on this, which is why you could summarize this into a small diagram or a figure or a flowchart and move on to larger discussions, which then brings us to a fundamental discussion as to how different is an ordinance from an ordinary law. So first things first, the ordinance which is enacted by the president is a legislative act and it's not an executive act, which means it is a law. Under the purposes of Article 13 Clause 2, ordinances are a law and ordinances cannot violate fundamental rights. And this, as I said before, is coextensive with the powers of the parliament. And therefore, if there is something on which the parliament can't make a law on, that is also something on which an ordinance can't be promulgated on. This is also true for state counterparts. Now, the idea here is that whether it's an ordinance or a legislation, in most cases when we talk about government bills, and we know the state of private bills in the country, not even 2% of private bills get actively discussed. The last time we passed a private member bill, I think, was in 1970. So most of the legislative action that happens on the floor of our legislatures has a lot to do with the will and the actions taken by the government. It has very little to do with private member bills or individual MPs or MLAs who are not ministers. So the idea here is the origin or the intent of an ordinance or a legislation does definitely come from the executive. But the difference is that an ordinance is passed on a current basis, which means that the ordinance is only for a specific time period, whereas legislative actions could be post facto. They could work across dimensions. Now, unlike the passing of a regular bill, there is absolutely no scope for a detailed discussion or a consensus building as far as promulgation of ordinances are concerned, which means that the only time an ordinance actually gets discussed is when the legislatures, whether it's the parliament or the states, actually get to approving it or not approving it. Similarly, because the parliament has the powers to make money bills and financial bills, and finance bills. Financial bills, I'm mistaken, is essentially a part of the budget, so don't make that mistake. So when we say finance bills, financial bills, so whether it's a money bill or a financial bills, because the Parliament can make a law on this, which means there can be ordinances on this as well. And I'll be very clear on this. In the exam, people make a very fundamental mistake. It's a money bill and it is a financial bill. But the second you use the word finance bill, the word finance bill is only and only used in the context of the budget, which is essentially an annual financial statement. But money bills and financial bills, and that's the correct terminology of this, is also on which ordinances can be issued. Because ordinance is like a law and law can be judicially reviewed, so an ordinance can also be judicially reviewed if it seems to be unconstitutional. Now, courts have of course held that the reasons or the motives of an ordinance can't be questioned in a court of law, but Supreme Court over a course of time through successive judgments has also looked into whether the material evidence on which you thought it was absolutely necessary could sort of be looked into it. The basic principle is that if you pass an ordinance which transgresses the limits of power mentioned in the Constitution, the courts can merrily strike it down. And speaking of the courts, you must understand that there are essentially three very simple but very, very important Supreme Court judgments which sort of give a lot of clarity as far as ordinances are concerned. And, there are no such things as coincidences, but there are coincidences. So when we look at the first judgment, R.C. Cooper versus Union of India, this is just around the time where emergency will get imposed at a point. This is happening around the time where the government has been taken aback by the Golaknath judgment. And at the same time, several constitutional amendments have been passed, and the government is essentially using powers under Articles 39B and C to further accentuate the primacy of directive principles over fundamental rights. So this is essentially challenging an ordinance which nationalizes the banks around that time. And that's essentially what the case is about. The facts of the case are not relevant for you to write in the exams, but it helps you remember what the case was. It's a 1970 judgment where the Supreme Court very clearly says that if the ordinance has not been passed because it was urgent, then you could bring it to court and you could test for its constitutionality, which is essentially what the bank nationalization issue was. Does the government legally have the powers to nationalize bank? Yes, it does. But the question is, did you have to take an ordinance route for it? And that, in fact, till today holds true. When we talk about the CBI and the CVC ordinances, what is the urgency behind it? For example, in 2021, we had a homeopathy council ordinance at some point. What is the urgency behind it? In fact, fundamentally, what was the urgency behind the farm laws to originally be introduced as an ordinance? You could have done this through a democratic consensus, and you could write this in your exams. You don't have to argue on the merits of the farm laws. You've got to argue on how farm laws were executed in the first place, because this, of course, seems to be a larger concern. However, despite a very strict judgment by the Supreme Court under R.C. Cooper, the government later on, through the 44th Amendment 1978, which you would also recollect is the amendment which eliminates right to property as a fundamental right and makes it a constitutional right under Article 300A. The amendment, the 44th Amendment, very categorically says that whether the president is justified or is the president satisfied that this is an urgent ordinance which requires urgently to be promulgated, this cannot be judicially reviewed because largely of separation of powers, and it is the mandate of the president. The president has been given direct constitutional powers. This later on gets evolved through Supreme Court judgments. Then comes the Dr. T.C. Wadhwa case, which is in fact a very, very well-known case. See, very interestingly, Dr. T.C. Wadhwa was a professor of economics in Pune, and he was greatly affected by the sheer number of ordinances which were being passed in Bihar. About 256 times the ordinances were about 256 ordinances were being promulgated, and they were essentially done very mechanically without any parliamentary action whatsoever. The Supreme Court took a very stern view and said, boss, the mechanical repromulgation of ordinances is absolutely unconstitutional, and the only reason that we will allow for ordinances to keep on being repromulgated after session is if it is extremely urgent, or the legislatures honestly didn't have the time to, which is a very rare case, because you would have time to reconsider it. If you've passed an ordinance 256 times, it's of course a matter of grave concern. So DC Wadhwa essentially becomes the Keswananda Bharti for ordinances, if you know what I mean. But it still does not answer a lot of fundamental questions that are still there with respect to ordinances. And the fact that the Supreme Court has played such an important role in evolving the jurisprudence around ordinances, has played such an important role in the way ordinances have to be executed, in the context and the application of ordinances, really speaks volumes of judicial review, borderline judicial activism, if it depends on which side of the coin are you. And the most recent judgment is the 2017 judgment called the Krishna Kumar Singh versus State of Bihar. Now, this was first to a lower bench and then went up to an appeal to a second higher bench, and then finally a 7-judge constitution bench gave a judgment. Which is why this question was asked in 2015, is because 2015 it was at a lower constitution bench of the Supreme Court. Now, this Krishna Kumar Singh judgment, very interestingly, also is with respect to the state of Bihar. And the facts of this case have a very, very uncanny resemblance to the DC Wadhwa case, which means, history often repeats itself. So basically what had happened here was that the state of Bihar had passed multiple ordinances, I think repromulgated about 7 ordinances. The same ordinance was repromulgated about 7-8 times, wherein the state government had taken over several Sanskrit schools, and the teachers of the Sanskrit schools would therefore then become government school teachers and would be entitled to pay emoluments and pensions like other government school teachers. This should have been passed by the Bihar Legislative Assembly, but wasn't passed by the Bihar Legislative Assembly. It kept on repromulgating itself to the point that it almost never reached the Assembly for discussion in the first place. The Supreme Court took a very, very strict view on this and said, boss, nothing doing. This was a majority judgment. There was a split. Some of the finest judges of our country were on it. And the Supreme Court very clearly said that, boss, you do not have an option. You've got to place the ordinance before the legislature. This is compulsory. There are no two doubts about it, and then don't even have a debate about it. And then said, what if an ordinance is taken back? What if an ordinance ceases to remain in operation? What if an ordinance lapses? Or what if an ordinance stops being in effect? What happens? What happens to the changes that ordinance made? It is dependent on essentially 3 tests. First, if what the ordinance wanted to do was irreversible, then the ordinance, once issued, could continue. The effect would continue till eternity. Second, it would be very impractical or logistically inconvenient or cumbersome to reverse the effects of the ordinance, and therefore let the ordinance effect continue even if the ordinance doesn't and the legislatures don't pass it. And third, there is some compelling public interest as to the reasons and the rationale behind it, because at some point of time maybe the legislature may have had a vested interest in so. And it is the courts of the country, the Supreme Court, who would ultimately decide on these 3 tests as far as the feasibility of an ordinance is concerned, even if it ceases to remain in operation. And that's essentially what Supreme Court and ordinances is about. Now, let's understand the conflict between ordinances and parliamentary democracy. See, in reality, the making of ordinances is a power with the ministers. But the satisfaction of the president, because the president is the signing authority, and it is the president which signs the ordinances for it to come into immediate action, That is also important, because, and that's the reason why the president is promulgating it, because the ordinances will have a national impact, and to create a safety valve of sorts, because the president is apolitical post-election, and the president is elected by members of the central and the state legislatures inclusively. So there is a degree of mandate with the president's office, and we expect the president to deal with ordinances in the most honest manner, in the most righteous manner. However, the satisfaction of the president, as we were talking about, cannot be questioned into as far as a court of law is concerned. And therefore, exactly how would you implement the ordinance, and exactly how would the ordinance come into operation, that is also left to the ultimate discretion of the president. These discretions are again not mentioned in the constitution, but derived, so to speak. Now, it is essentially very similar that how the judiciary cannot question the legislative intent, but essentially look at the constitutional validity of it. And the second the judiciary gets into the intent of the law, you cross the judicial review stage and you get into the activism state. And of course, intent is often questioned. It's not that intent is not questioned. That's essentially what due process of law is based on. If you see over the last few years, because there has been an increase in the number of ordinances, there has of course been a larger debate on whether you're using ordinances for the right reasons. And as we are talking about it in the context of the Supreme Court, whether it's the DC Wadhwa case, where the Supreme Court very clearly said it's an emergency power, should be only used where there's an immediate action which is necessary, and that action can't be taken by the legislature because the legislature is not in session. And this is contrary to all forms of democracy. This is contrary to all forms of parliamentary democracy, because the executive essentially has the power to make the law, and therefore such kind of a last resort power and emergency power should be very, very limited. And the idea is, what can't be done directly should also not be done indirectly. This is also a simple interpretation of the doctrine of colorable legislation. The idea is, a constitutional authority can't do indirectly what it is not permitted to do directly, which means if you are not allowed to bypass the parliament, then don't use the ordinance as an excuse to bypass the parliament. So if you're trying to just bypass or subterfuge, then it would essentially be a fraud on constitutional provisions, which is essentially what was happening with the DC Wadhwa case. There is no rational basis. It's not urgent. Even if it was urgent, you could not find time, and you had to promulgate the ordinance 256 times, more than 200 times for sure, and that just doesn't make sense. No doubt, the satisfaction of the president cannot be examined by the court, but the court can look into it, whether you've sort of gone beyond what the constitution wants you to do so. If it's not urgent enough, if you're doing it because you want to bypass the parliament, and whatever reasons you are basing your decision on, those could therefore be questioned in a court of law. And that's essentially what repromulgation and satisfaction is concerned. Though the idea is that you can't question what the president is trying to say. We understand that. But if it is very apparent that the reasons for promulgating the ordinance are malified in nature, then of course you can question. And fundamentally, the ordinance is not a permanent measure. It is a stopgap measure. We need to keep the wheel moving. We need to take an action. That is why we're taking an action. For example, when the unfortunate Delhi gang rape incident had happened, the criminal law ordinance was essentially much needed, because the fervor of the country necessitated for it, demanded for it. But there's absolutely no reason for farm laws to be to face ordinances. There was no imminent urgency for it. Even for that matter, the tribunal reforms ordinance. What was the absolute urgency to quash tribunals so immediately? You could have done it later on. You could have done it through a proper parliamentary action. So that's the basic idea. So the idea is that, why are ordinances even existing? Why would the ministers, or why would the government want it? It's because there would certainly be reluctance to face the legislature on certain issues. For example, farm laws. Second, you would obviously fear defeat in the upper house, where governments often lack the required numbers. And third, this, once you do reach the parliament, there would always be a standoff, there will always be a heated debate, and the opposition, being the opposition, would disrupt and might not even let a productive discussion happen. Keeping this in mind, as you were talking about the Krishna Kumar Singh judgment, which we spoke here, in this case, the Krishna Kumar Singh judgment of 2017, the 7-judge bench very clearly said that if you don't place an ordinance before the legislature, you somehow let it not get discussed, get it automatically lapsed, and then we keep reintroducing it, it's not going to work. It's absolutely not going to work, and that's something that is absolutely not acceptable. And they essentially relied on the DC Wadhwa case as well, and therefore this judgment, especially the Krishna Kumar Singh judgment, widens the scope of judicial review and also gets into whether the president or the governor had reasonable reasons and did examine the rationale behind the ordinance. And it also helps you to maintain constitutional decorum and legislative control over lawmaking. The idea is the use of an ordinance must not always be looked at as a cynical move. Sometimes you may have to do it because it's the need of the hour. But the idea is only use it when the times are tough. Only use it when you don't have any other option. Don't use it to score brownie points with your ultimate janta, with your ultimate electorate, and essentially work in a more cooperative form. And the idea is, in very rare cases, sometimes because we lack a constructive opposition, you would want to get this out. You would want to tell the people of the country that, you know what, this is a good law, see how this works, it's going to benefit you. So there are, of course, two sides to this, which is why ordinances, as much as it is a legal issue, it also becomes an ethical issue as well, because sometimes a disruptive house itself constitutes a compelling circumstance. And this is it. If you're able to look at these basic arguments around ordinances, you are sorted. You would really not need anything else as far as ordinances are concerned. Thank you, and I'll see you in the next video.